Civil Judge Junior Division and Law Examinations, Law of Evidence, Dying Declaration, etc. Persons who cannot be called or attended as witnesses. Section 26, Clause A to Clause H of the Bharatiya Saksha Adhiniyam 2023. Its corresponding section 32, subsection 1 to 8 of the Indian Evidence Act 1872. Dear student friends, today I wish to take up most important topic, burning topic from Law of Evidence, that is section 26, Clause A to Clause H of the Bharatiya Saksha Adhiniyam, which lay down various provisions relating to death, dying declaration and other 7 situations under this section. The provisions of this section 26 are same, remain unchanged in Indian Evidence Act and this Act. In Indian Evidence Act, these 8 provisions were given in section 32, subsection 1 to 8 with subheadings. These 8 provisions. In new enactment, Bharatiya Saksha Adhiniyam, whatever provisions were there under section 32, 8 provisions, the same 8 provisions are incorporated in Bharatiya Saksha Adhiniyam under section 26, Clause A to Clause H. So that is the reason why by the time prior to July 19, prior to 1st July 2024, I started uploading Indian evidence, uploading the lectures on evidence. So far as the lectures till date, what I uploaded, whatever was there in Indian Evidence Act, the same contents remain unchanged till this dying declaration, but the little changes that were made are only section numbers, wherever changes took place, how the sections arrangement was made. I had already enlightened you in the previous classes. One more thing I wish to tell you is, I am uploading these lectures under the caption Civil Judge Junior Division and Law Examination with an intention to upload as many lectures as possible in depth, each and every topic in detail, covering almost sometimes I am covering the topic in section wise, how they are explained in high standard books written by, authored by eminent authors. So that is why, dear friends, if you follow my lectures, these lectures, this information will be enough for not only for LLB student but also Civil Judge Junior Examination and LLM student. If the same subjects are repeated in your LLM studies, whatever subjects you studied in LLB, the same subjects you take a specialization you continue in LLM, the topics will be, my lectures will be enough. However, the LLB students may feel that it may be standard, may be more or something, but this much standard is necessary from the prestigious institutions of legal studies in India, and also those students who won't be able to follow this much lecture, whatever they remember will be enough to meet their requirement to get through the examinations, dear friends. So now, so in addition to that, I have uploaded more than 250 lectures on 18 main subjects. So I sincerely suggest you to follow my lectures. So even if the some amendments took place, subjects are decodified, the subject is almost one and the same. My lectures which I uploaded from the beginning in the last 6 years. Each and every lecture will be useful today, in future also, because the law remains unchanged. While reading books, you come across so many cases and principles which were prevalent in 1950. So here this Evidence Act was passed in 1872. So many years the same law is there still in Bharatiya Saksha Adhiniyam also. The almost all same provisions are repeated. So dear friend, if you can go through the amendment, it is enough. But whatever lectures I uploaded from the beginning to till date, they will help you to get through any examination successfully. Now coming to the subject, section 26 of the Bharatiya Saksha Adhiniyam lay down various provisions relating to dying declaration and other situations. So here the body of the section tells you who are the relevancy of evidence. So the court in judicial proceedings, civil or criminal, takes into consideration evidence given by the witnesses only. The evidence is main source to decide any case to this. So this there are general rules are there in every subject, exceptions are there in many almost every subject. So the why general rule is there, why exceptions are there means, so law will not insist anybody to do what is impossible. So law, this is what is called the doctrine of frustration, enshrined in a Latin maxim, lex non coget ad impossibula. Lex non coget ad impossibula. This means law will not insist anybody to do what is impossible. This topic I explained in detail in Contracts Act. So that is why in many subjects, CPC, CRPC, IPC, whatever is there, so in almost all Contract Act, some general rules are there, so many exceptions are there. Accordingly, in Indian Evidence Act yesterday, the Bharatiya Saksha Adhiniyam today, in Indian Evidence Act, section 5 tells you the general rule, who can testify, whose statement, whose evidence is relevant. But it provided exceptions from section 6 to 55. Means there were 50 exceptions under old law. In new law, section 3 tells you the general rule, who can testify, whose evidence is relevant, which evidence can be entertained. That is, where means of evidence, mode of evidence, and persons who are qualified, who can testify the evidence. These aspects are there under section 3. Section 4 to 50 will give so many exceptions. Accordingly, section 26 in Bharatiya Saksha Adhiniyam and section 32 in old Indian Evidence Act provide some exceptions. So even though there is no primary evidence or direct evidence, documentary evidence, etc., alternatively some other source of evidence given by the witnesses can be taken into consideration. Accordingly, earlier section 32, today in Bharatiya Saksha Adhiniyam places before you 8 situations under which evidence given can be entertained. However, the evidence is accepted from the person who are dead and who are in coma, whose whereabouts are unknown, which statement is recorded in a document, which statement, like that. Some 8 situations are there which I want to explain you in detail. The opening words of the section 26 tells you relevancy. When suppose a person, there are qualified, who are qualified to give evidence, means who can testify the evidence. That is their general rule. If the general rule, the qualified witness is not there, if qualified witness should be there, he should come to give evidence. But sometimes qualified evidence may not be there, that person also cannot come and give evidence. Suppose dying declaration. In dying declaration, a person met with some accident, or some person fired at him, and some person beheaded him, and some person A stabbed B, but immediately he won't be nobody there is no chance to go to court and give evidence, but that person who is about to die will tell to the bystanders, so and so hit me with his vehicle and ran away. That is hitch and run cases. So and so kicked me with stabbed me with a deadly weapon. Like that, he gives some statement and dies. Whatever statement is given, whatever declaration is made by that person is called dying declaration. Whoever heard it and whoever witnessed it, one person or two person, more person, single person, two or more persons may witness and communicate the matter to the police and court, that particular dying declare, that particular issue can be accepted. So whatever is said and by a person and dead immediately or subsequently, who can never appear before the court, still that the dying declaration about as to the cause of his death or under circumstances that resulted in his death, will be taken into consideration as relevant, and the court will decide the case. That is one thing. So, under this section 26, Clause A speaks about a declaration or statement, oral or verbal, by dead person will be accepted. That is dying declaration. In addition to that, there are 7 situations, 26A, 26B, 26D, ED, CD, EF, GH, up to what are these 8 sections? I will tell you in this. So basically, as per the body, who are the person who cannot come to court and give evidence? Number 1, dead person. Number 2, the person who cannot, he gave evidence and his whereabouts are unknown. According to a person whose whereabouts are unknown for a period of 7 years under section 11 of the Bharatiya Saksha Adhiniyam, the corresponding section 108 of the Indian Evidence Act. So, if a person is not seen for a period of 7 years, his whereabouts are unknown, he is deemed to be dead. If any person tells that no, he is not dead, he is alive, that person has to prove beyond all reasonable doubt that that particular person is alive. So, this is what we study in burden of proof, a very important topic in future, dear friend. So, person who is dead cannot come and give evidence in court. Secondly, person who cannot be, whose whereabouts are unknown, who cannot be called. For example, in some in birth register, so whether the date of birth of a particular person is questioned in court, how to find out for date of birth? His certificates can be done, or the certificate, his birth recorded in hospital where he was born is to be traced out. The doctor who recorded the date of birth in birth register may be transferred, or wherever the doctor is, whether alive or not, we don't know. His presence cannot be detected, cannot be found out. That person cannot be called for to give evidence. So like this, will is there, the will is there, in will also the testator writes something, and after he died, he cannot be called and give evidence. We want to follow the contents of the will. In sale deed, some documents are there, like that. Like this, there are 8 situations we are going to take up. Now, this the section 26 tells you evidence by person who is dead. That is dying declaration 26A. 26B, and there are for some 26 to B to H fall under 3 situations. That is, a person who cannot be called, whose whereabouts are unknown, as per 111 Bharatiya Saksha Adhiniyam or 108 Indian Evidence Act. Thirdly, the person is there here, he is in coma, he is in a mental disorder. When he was in conscious condition, he gave evidence, or he gave some report or something, oral or written. Dying declaration is a statement, oral or verbal, by a person who is about to die. Who is about to die, or by a person who cannot be called, to give, cannot be called to come to court and give evidence under the circumstance. A person whose whereabouts are unknown, we cannot call, we don't know where he is. Some police officer recorded some statement in police diary, and whether he is transferred, whether he is in service or retired or dead, we don't know. We cannot ask him to call for the evidence. So third one is, the person is available here, he is in coma, he is in mental condition, his mental condition is not good, he is not in a position to tell what is right, what is bad, he is mentally deranged, a mental disorder is there. That man, even though he is in prison, we cannot call him to court and give him evidence, because he is not qualified, he cannot testify any evidence. If earlier whatever statement he was made in a conscious condition, that statement recorded will be taken into account. But when there are so many situations wherein the court will call the witnesses again and again. First time, while giving evidence, he was in conscious condition, he would able to testify and give evidence, but subsequently, if we require, we don't know wherever, in which state he is, which country he is, we cannot say. So that is, he cannot be called. That person is there in front of us, where previously while making statement he was in good condition, today his condition is bad, he is in he is mentally disorder, he is in a deranged condition, so we cannot. Or he is in coma, he is in unconscious state, though not in coma, he is in unconscious state, he is on bed in hospital, he cannot come and give evidence. So that is another category. The next category is first one is death, second one is who cannot be called, third one is who is in ill or anything, and the last condition is whose presence involves long delay, or highly expensive. Suppose a person is to be brought, there is a lot of technical procedure is there. In order to bring a person, there will be a very big delay, long delay and expensive. We cannot ask that person to come to court and give evidence. Or he is in US or Canada, so it will take a lot of time. Coupled with visa formalities are there, visa formalities and other things are there. We cannot call, but in order to call him, the court cannot call a person from US, Canada or any distance which requires 1 day, 2 days or more than 2 days, like that. We cannot. That is last situation. Or anything that, not only that, it will be expensive. It will be very expensive to bring that person under these situations. So either dead person, either by death, one cannot be called, one cannot come and give evidence in court, and some other these three reasons due to whereabouts unknown, whether alive or dead we don't know, wherever he is dead we don't know. Second situation. Third situation, ill health, mental disorder, an unconscious condition is third stage. Fourth stage is inordinate delay and expensive to bring a man to give evidence. So these are the basis on these 4 points. There are 8 situations are designed. 8 situations are designed. These 8 situations are: number 1, statement, dying declaration. The person who is about to die makes a statement. Then what is dying declaration? This is the most important topic. I will explain in detail. Other section, class B to H, they are simple topics, small topics. There you have to know, and the questions may not be asked on this. If at all asked, only short notes may be asked. But first, section 26, class A, which speaks about dying declaration, is most important from examination point of view, not only for LLB students but also in judicial officer exam and other in LLM level evidence is there. That is also they also can take it for granted. This is most important topic. So here there are 8 situations. 8 situations. What are these 8 situations? Section 26, class A to H, Bharatiya Sakshya Adhiniyam, class A, class B, and so on up to class H. In Bharatiya Sakshya Adhiniyam, heading is there containing a dead person and who cannot be called for the following reasons, and 8 situations. So the side headings are not given in class A. They are given like a class A, B, C, D. In old act, side heading for every topic is given. Section 31, 32, subsection 1, statement by dead person, and statement in course of transaction. All these side headings are given in old act. In new act, side headings are not given. So that is why, even though side headings are given, for memory purpose you can put side headings of that particular topic and continue your studies. So first one is dying declaration. I will explain in detail about it. Second one, second situation is 26B, statement made in course of business. Statement made in course of business by in discharge of duty, in discharge of profession. Any statement is recorded. Any statement is recorded in any register, and any document is maintained in any register. The person who recorded that statement, who maintained that document, whether this recording of the document is genuine or not, the court will believe depending upon the circumstances of the case, as whether he himself has written or not. We cannot ask him to come and because some 10 years, 20 years back, that statement is recorded by one doctor who attended delivery of that particular lady because of death, birth certificate. Similarly, the person for a death certificate also, the doctor who attended the surgery and that surgery was failed, for that also it is important. So many questions. Some when FIR is filed, the police will go and take up investigation. If it is cognizable offence, without orders from my magistrate, with orders from magistrate in case of non-cognizable offence. See, then whatever he recorded in that particular police diary, and basing on that the police report is submitted, whether that the matter is correct or not, to find out, we need the police officer. But that police officer who took up investigation long back, where in which place he is transferred, whether he is alive or not, whether he is in service or not, these things. So that that type of situation will come under section 26 clause B. The third one is statement made against proprietary or pecuniary interest. This is what is called self-harming statement. Admissions available in admissions available. Admissions means acknowledgement of liability. Admissions and confessions, as I told you, self-harming statements in civil cases are admission, self-harming statements in criminal cases are confession. These topics I told you. Another thing is like that, if a declaration, if anybody said that the state was made a statement, because of that statement he will lose property. It is a loss. That statement is a loss to his property, or that statement is a loss to his that way. By that statement, that person, the maker, the declarant, loses money. Then that statement is said to be relevant, because this type in section 19 Indian Evidence Act, civil litigation is there. In section 25 confessions, that is there. There the persons can come again and give evidence, but here the person cannot come and give evidence. That is why the person can be recalled again, but here the persons cannot be recalled. That is the difference. So if a person gives a statement, that statement is relevant. That statement, he made that statement, log back, it is recorded through witnesses orally, by oral, some oral witnesses said it, or it is recorded in document. So then statements, self-harming statement made by the declarant long back, such person cannot be called again. Wherever he is, whether alive or not, we don't know. That is a statement, that is self-harming statement. So statement against the proprietary or pecuniary interest of the maker, proprietary or pecuniary interest of the maker. For example, somebody said, A purchased property in favor of B as Benami transaction. So later A says that I purchased property in favor of B to leave it for him, B only, for his only, to make him some property holder, to make him, to promote his financial position. That is, he is losing the property. Similarly money. Suppose adoption deed is there in case. In adoption deed, natural sons give we give attestation. When natural sons give attestation, they are losing the pecuniary interest of the money and gold or anything, whatever it may be, that is there. So when once you are acted as a witness, means you are agreeing that somebody is adopted son, that adopted son also is entitled to property or cash, everything. Some pecuniary loss, proprietary loss is there. So that is section C, that is clause C, section 26C, A, death, B, document statement made in course of transaction. Section C is statement made against proprietary or pecuniary interest, and the fourth one, D, statement made as to public right or custom or matters of general interest. Suppose there may be a village, there is a particular area, whether it is a public right, whether all people are having right over that or not, whether there is a public right or not, whether there is a public right means right on highway. You know, so many private companies, every vehicle cannot go into that through the security. That is the private road. Public road, every vehicle can go through that, whether it is a public highway or private highway. and whether particular area Ram Mandir is there, Masjid is there, that traditionally made some people made statement given by the persons long back about who physically witnessed, whether it is a public way or a private way, that whether the place for masjid or mosque or place for mandir, all these things are attracted under this area. So who made such statements cannot be called again wherever they are, however they are, we won't be able to get back. So the statements made against statements made as to public interest or custom, what is significance of custom, what is customary right, all these aspects are explained in detail in so many subjects and so many situations. And the matters of public interest, there are so many matters of public interest. Public place means any shopping mall, everybody can have public. Road is a public place, cinema hall is a public place, market is a public place. In a market certain things are there, they are for the common interest of the general public. They can be utilized by everywhere, they can be utilized by everybody. So these are the this is fourth point. Now fifth point is section 26 clause E. This is section 32 subsection 5. So existence of relationship, either blood relationship or family affairs. Section 5 speaks about existence of relationship by blood. So and so is my son, so and so is my daughter, so and so is by blood or by marriage or by adoption. Whether the question arises, whether A is wife of B, whether C is husband of D, like that. The whether so and so is son of so and so. So to parental child relationship, some statements are there. Whatever is given in DNA report will reveal the blood relationship. The person who has undertaken this DNA test may not be available there. So in certain foreign countries, there may be the polyandry in there, they may take that DNA test. For Indian civilization, the DNA is not there, but the question of DNA came into picture in the recent past in respect of a woman who claimed so and so is my father. You all know it appeared in newspapers also. But these things also blood relation for section 26 clause E deals with relations, existence of relationship. Section 26 clause F, that is sixth point, deals with family affairs. So the disputes relating to the family, particularly whether in under section 26 clause E or 26 clause F, some dispute must take place with reference to property or other pecuniary benefit, and that in that dispute we have to clarify in blood relationship. In relationship, the dispute relates to dead persons and living person. The family relation, the dispute relates to only between only dead persons only. That is there. And the next point is statements made in documents relating to transaction. Statements made in document relating to transaction. So whatever statements are made in sale deed, gift deed, mortgage deed, in this case whatever contents are there, by the time that mortgage deed is executed, by the time the gift deed is executed, by the time the sale deed is executed, some particulars are furnished there. The person who executed that particular sale deed or not may not be available at the time of the judicial proceeding. Still, basing on the, for example, some house is is there, the disputing house is there, there are boundaries are there, east some building, west some building, north some south some high road, north some yes building, like this. So in the question is any question relating to the property title is comes into question, then the boundaries are to be taken into consideration by going through the contents of the sale deed. Then this is what is called seventh point, section 26 clause G. Last point is clause H. Statements of several persons, expressing their feelings or opinion. We know we the members of the public have some common feeling, common opinion about particular thing. Mahatma Gandhi is good, great person. This is a common. Ambedkar is great person. He contributed a lot to uplift the downtrodden community. Subhash Chandra Bose is great. Sardar Patel is great. Like that. So and so is a very bad man. So and so is a very cruel man. That is there. So and so is a corrupt fellow. So and so is a most honest fellow. There are some opinions are there in a village. So and so is a good man. So and so is a bad man. So and so is a cruel man. Like that. It's like that. So and so is auspicious man. Like that. Anybody tells Mother Teresa is great. Anybody tells so many. There are so and so as Prime Minister is very dynamic and very powerful, like that we will say. They are what are called feeling. Similarly, some feeling so and so department, that is corruption department. So and so field, that is not good. The woman should not join that particular field. So that is, there are some opinions are there. Some opinions are there. We should not mention in depth. So these are those public opinions were made and recorded and are supported by the oral evidence. The person who made that statement or public opinion cannot be called again, and such statements can be taken into consideration as relevant and this thing. So these are the exceptional cases. Now the first topic, dying declaration, we have to discuss in detail. If time is there, all 7 points we repeat once again with case law. Dying declaration. What do you mean by dying declaration? Dying declaration is a declaration or statement made by a person who is about to die or as to the circumstances that resulted in his death. So dying declaration is a oral or verbal. Is a oral. So and so killed me. So and so hit me with his vehicle and ran away. So and so killed me with his revolver, like that. So the person in blood-stained clothes, who is in lost in conscious condition, gives statement. That is the person who is about to die made a statement and died. That is what is called dying declaration. It is oral or verbal means only words that come out from the mouth are oral. Verbal in the sense they also include written content. So he is not in a way able to speak by moving his head or moving the hands, writing something with his blood on the floor, something they also include in verbal. That is why it is a oral or verbal statement made by a person who is about to die or any other circumstance that resulted in his death. Any other circumstance resulted in death means there is a dowry problem, they are consistently harassing me, and ultimately my mother-in-law or brother-in-law or sister-in-law poured kerosene on me and causing my death. So that is what she can tell you. As a consequence of that, she should. All these rules I will tell shortly. So this is about dying declaration. So for example, A attacked B with a deadly weapon and A died. A attacked B, B died. B made a statement. A along with his companions attacked me with a deadly weapon and killed me and then dies. That is dead. Circumstance as to this. The circumstances that resulting in death. Circumstances that resulting in death means so and so, these are the some transaction is there. Some I gave a loan to somebody. Several times I asked him. He did not give. He called me to. I gave loan to somebody. He did. I made several reminders. He did not give. He called me to home. And he called me to home, and he thereafter he did not give money. On the other hand, he put poison. He gave poison in a food and sweet meat, and I took that food and died. And Hindu Samanta case in Resgeste, Pakala Narayan Rao case in these things I will tell you. What are the circumstances that resulted in death? What is the direct situation? These two aspects I will give case law on this. So the term dying declaration is not defined in Bharatiya Saksha Adhiniyam or previous enactment Indian Evidence Act. Section 26 clause 1 gives the reading of the infraction concept. Dying declaration is a declaration or statement made by a person who is about to die or the circumstances that resulted in his death. This is the definition, and there is a big definition. All these things, this definition contains what I have explained till now. And so the definition of dying declaration was given in by Supreme Court in Ram Bihari Yadav versus State of Bihar. So whatever the content is, it is a statement made by a person who is dead as to the cause of his death or circumstances as to death under so many situations that resulted in death. These 8 points we have to cover. That is the decision. Let us not waste time for this. And this is dying declaration. So why dying declaration should be accepted at admission? The court is consistently telling you only the persons who are qualified to testify alone can come to court and give. The primary evidence is necessary, documentary evidence is necessary, and so many conditions it is putting. But still, so far as Section 3 of Bharatiya Saksha Adhiniyam is concerned, all the general rules are there. But Section 5 previous act, the general rule is there. But so many exceptions are there in old act from 6 to 55, 50A, 50 situations are there. In new act, section 4 to 50, 40 sections situations are there. These all provisions are same, but the section numbers are adjusted. And some 3-4 sections are clubbed in confessional statement. That is, the confessional statements to police are given in 3-4 sections in Evidence Act, and all were put in Section 25 in this new enactment. So that is why the number of sections are reduced. So the provisions are accommodated. 3-4 sections are accommodated in one section, and new sections are created. All these developments I told you in the previous classes. Now, conditions for admissibility of. So here the dying declaration is not final. The dying declaration to be valid and acceptable, if the court, whether every dying declaration is not accepted, the dying declaration to be admissible in evidence, some conditions are to be satisfied. Number 1, the person who made the declaration must die subsequently. He should not survive. But however, in rarest of the rare cases, as per Section 26A, if the little ray of survival, and that may be taken into account, but in English law, but when a dying declaration in the sense, it is only death. No question of survival, little ray of survival should not be there. And secondly, dying declaration relates to civil and criminal proceedings in Indian law, but in English law, dying declaration is accepted in criminal cases, that in homicide cases. Homicide cases means a human killing case, killing of human being cases only. But in India, not only human being cases, but also all criminal cases, and in civil cases also, the dying declaration will be taken into consideration. The CRPC, these provisions will come with relating to the property disputes and all. So here, so secondly, the person who is giving the dying declaration, it should be established that the cause of death must be as a consequence of the injuries inflicted. As a consequence of the injuries inflicted. So you see, he was stabbed with a deadly weapon. So of some spear or something, a big iron rod like this. So as a consequence of being he was hit by that particular iron rod, as a consequence of that being hit by iron rod, the death must be resulted. No, suppose he is suffering from some disease, serious disease. Some two hand blows are given, and he is hospitalized. While in hospital, he died of not of these one or two blows, but he died due to the disease which he was suffering. So the dying declaration, there is no any consistency, there is no any proximity, there is no any nexus as to the cause of death and injuries inflicted, then the dying declaration cannot be accepted. So dying declaration to be acceptable, dying declaration to be admitted by the court, the cause of death must be as a consequence of the injuries inflicted, the injuries or deadly injuries inflicted by the accused. That is another thing. So thirdly, while giving this dying declaration, the person must be in a conscious state. He would be able to know what is right, what is wrong. Suppose serious injury, serious blow was given, the accused gave serious blow on head, his brain condition of his brain became out of order, he lost consciousness, he doesn't know what is right and what is wrong, he became mad. Even then, if he may speak something irrelevant to that type of dying declaration cannot be accepted. So this is for admissibility of dying declaration, these things should be there. Another thing also, the dying declarant should not give declaration out of vengeance. Rivalry. He wants that somebody killed him, but he doesn't like to, the servant killed, but he doesn't like to kill, but some other rich man who has with whom he has rivalry, he should not tell his name. It is found, then the dying declaration is not. So vengeance, the declarant should not say some other's name out of vengeance or grudge or family rivals. So these are the conditions to be strictly adhered to entertain these dying declarations. So what is the reason why court admits dying declaration? Court is consistently telling under Section 5 Indian Evidence Act or this Section 3 Bharatiya Sakshya Adhiniyam, the best means of evidence should be there, document should be documentary evidence or primary evidence or direct evidence, eyewitnesses, all these things telling why they are taking dying declarant, taking nobody came to court and gave evidence, nobody saw anything, no person relating to court did not see, no, they were not present at the scene of the offense, but still why court is entertaining this? There are some reason. In dying declaration, the victim, the aggrieved is the sole witness. The aggrieved is the sole witness. If his evidence is not accepted by the court, if the evidence is not accepted by the court, evidence is not accepted and excused, it will defeat the ends of justice. So, the primary obligation of the court of law is to provide justice. When an aggrieved was hit and killed, the culprit must be punished. If the dying declaration is not accepted as evidence, the culprit will escape from liability. He will commit so many murders. So, the ends of justice will be defeated, but dying declaration is the only evidence, sole evidence. It must be entertained, otherwise it will defeat the ends of justice. That is first reason. Second reason, a person who is about to die, under the presumption that any person who is about to die would normally speak truth only. Nobody will speak false statement. In so many movies we see the villain at the time of death, he will tell good to the hero. But because at the time of death he thinks that why should I speak wrong even at the time of death. Like that, any bad man may become a good man at the time of where the time he is about to death. So that is why victim being sole witness, his evidence should not be excluded in the interest of justice. If otherwise, it will defeat the ends of justice. That is first reason. Second reason, anybody at the time of death, before going to meet his fate, would normally speak good. He would never speak lie. That is second. So there is one more reason. There is underlying principle of dying declaration. Why dying declaration is allowed as sound evidence? Because that maxim is there. So the concept of dying declaration is based on the maxim, underlying principle, that is maxim, nemo moriturus presumpter mentiri. Nemo moriturus presumpter mentiri. This is available in law and textbooks, don't worry. Nemo moriturus presumpter mentiri. This means a man will not meet his maker with a lie in his mouth. A man will not meet his maker with a lie in his mouth. It is commonly, universally accepted by the people of normal common sense that we are born with the blessings of the God. We must go to God one day or other. One day or other. The people with who trust Dharma and all, they believe that we are the products of God. All the products should reach the God. So that is why, so a man who is going to reach his maker, he will go with clean mouth, decent mouth. He should not keep lie in his mouth. So this meaning of this, a man will not meet his maker with a lie in his mouth. That is first reason. Suppose a man who is about to die will go to heaven or somewhere to God. He want that his mouth should not contain any lie. So the truth lies on the person who is about to die. Truth sits on the lips of the person who is about to die, or the truth sinks on the lips of the person who is about to die. So that is why the dying declaration is presumed to be true and is accepted or entertained as evidence. And there are some, however, some corroborative evidence also is required to be produced by the court in the event of doubt. So corroborative means there is supporting evidence also will have to be produced. In some cases it is accepted. Now here the law relating to this thing. So the English law and Indian law. In English law, survival, if a person must die, if survival is there, the court will not accept. In English law, only homicide criminal cases only dying declaration is accepted. In Indian law, not only homicide cases and other criminal cases and civil cases also dying declaration is accepted. Dying declaration is accepted. When dying declaration is not accepted, suppose the declarant is in unconscious stage, he doesn't have any mental condition, he is not able to tell what he is, what he is telling. That is, if he is the dying declaration is arranged and abetted by somebody, or it is done due to take vengeance on somebody, there is no any causal connection, nexus or consistency with what he to his death and injuries inflicted. He was already a serious patient. Some small blow is given by the accused. He is hospitalized with that small blow, and in that hospital he dies as a consequence of the disease he was having, not as a consequence of the injury inflicted. That is there. That is what is called. So these are this is when under these circumstances dying declaration is not accepted. When dying declaration requires corroboration, dying declaration corroborative evidence means only there is no hard and fast rule that dying declaration is taken for granted. It must be accepted by the court. In the events of doubt, the court also will insist some other supporting evidence, that corroborative evidence, to take into consideration the dying declaration. Now we like to now I take up case law. So the very opening words of 26 here tells you the statement oral or verbal made by a statement or declaration, oral or verbal, made by the person who is about to die. That means somebody stabbed me with iron rod, I died. That is direct. So somebody, but he told the circumstances of the case. So I gave loan, I gave loan, but he did not give it. I made several reminders. After some time he called me. I went there, and but there that man did not come. His wife identified the body and all. That is Pakalnaran case. We are going to tell you. For direct attack, that is what is called Empress versus Abdullah. Empress versus Abdullah, direct. So in Empress versus Abdullah, there was some Dolari, a woman name was there. A woman was there. His name is Dolari. There was some property dispute between this Dolari and Abdullah. Before earlier there was the kings ruled. The king was called emperor, and if queen was ruling, she was called empress. Emperor means the sovereign, that is king. Queen, she is the sovereign, lady sovereign. She is empress. Emperor, empress. Prince, princess, like that. How we call prince, princess, king, queen, king's son, prince, king's daughter, princess. Emperor means the ruler, who occupied the chair as the ruler to rule the people. Like the Empress versus Abdullah. In this case, what happened was a woman, Dulari, the accused cut her neck, and with blood-stained condition, she went to the hospital, followed by the court personnel. She made statements. Magistrate put so many questions. Though she was not able to speak clearly, she was giving, she was responding appropriately according to the questions posed by the magistrate. These her nodding of head, moving of the hand constitute dying declaration, and the accuser was punished. The accuser was punished. So that that is what is called direct as to the cause of the death or circumstances that resulted in that. So the Pakal Narayan Swamy versus Emperor is a 1939 Privy Council case. Before the establishment of Supreme Court, the apex court for all the high courts in India was Privy Council was there in London. So this case was decided there. In this case, what happened that sometime in 1930s, there is in Kakinada, Andhra Pradesh, Kakinada, the nearby one village, one town is there, Pittapuram. There was a Pittapuram Jamindari. In that Pittapuram Jamindari, one official is there. He was called Diwan. He has some daughters. One of his, he has some peon by name Nokaraju of about 40-year-old. And one of his daughters fell in love with this peon Nokaraju. Peon fell in love with his Diwan's daughter. But later, that girl got married to another man by name Pakala Narayan Swamy, accused in this case. And after marriage was performed, the girl and went to his husband place, Pakal Narayan Swamy's place, Barampur. After some time, the girl along with husband came to his father's house where the Nokaraju was there. And as usual, she, as and when they needed money, this woman took hand loan from Nokaraju now and then, and total amount of 3,000 rupees. And they did not give it. They returned to Barampur. But when Nokaraju demanded for return of money, Pakal Narayan Swamy once wrote a letter to Nokaraju family, you please come to Barampur, I will give your money back. That 3,000 rupees in those days was a very big amount. It might be now more than 3 lakhs today, or even very, very big amount in those days. So he went to Nokra on the same day. He started for Barampur to collect the money. He did not return back. That is September 20th he received letter, 21st he started, 23rd his body was found. So that body was found in a Puri railway station in a steel trunk box. So, and when the police, when a trainee stopped at a particular place, they will examine each and every compartment, and one of the compartments, the steel box containing a steel box was unclaimed, steel box was there. When the railway police checked it, some foul smell was producing. After opening that, they detected the body of this Nokaraju cut into 7 pieces. And when they started investigation, the body 7 pieces were identified to be the body of Nokaraju. By Nokaraju's wife identified it. Then started investigation. They find they traced out the persons who are making that type of, who are dealing with sale of that trunk boxes, and they went to the trunk box dealer. He told the person who purchased that trunk box, and that Narayan Swamy purchased. He went and arrested him, and he was convicted to death. So these are the various circumstances. The Nokaraju did not give any dying declaration, but he died. Even though he died, he did not give dying declaration, but so many circumstances that resulted in death were taken into consideration, and the accused was convicted. So this is the position with reference to dying declaration. And next thing is, so far as other points are concerned, so 26B or 32(2) of Indian Evidence Act. So cause of business. A statement made in course of business. Any statements are made in discharge of a duty, in discharge of profession. Those statements can be recorded. For example, the police officer after getting recorded registered FIR, he will start investigation with instructions of magistrate or not. During the course of investigation, he arrives have said so many facts. Those facts he recorded in police diary. After recording all the facts in police diary, the police report will be prepared and will be submitted to the court for follow-up action. So this any information relating to the fact in issue, it relates to the statement furnished by the police officer in investigating report, that will be taken into consideration and taken as relevant. But it is not possible to the police officer who investigated that particular case, in which place he is, which state he is, whether in service or not, the position cannot be found out. But still, basing on the reason that that person cannot be called for giving evidence, we cannot deny that statement. It will be entertained under section 26 clause B of the Bharatiya Sakshya Adhiniyam. Next one is section 26 clause C or section 32 subsection 3. This speaks about self-harming statement. So the maker, if the person who made statement against his proprietary interest or pecuniary interest. Suppose I make a statement, if that statement causes loses my property, by making the statement I will lose my property. By making some statement, I lose money. So such statement is accepted, take it for granted and relevant. The person who made the statement may not be available due to death or some other reason. Due to death or either he may die, whether he is alive or not, we don't know. Whether he left, he resigned, these are wherever he is, we cannot. That person cannot be found. This is what is called this. So here the relevant case on this point is Beam Singh versus Kaas Singh. Beam Singh versus Kaas Singh. Here the deceased person purchased property in Benami. Generally, it is most common that many people purchase the property in the name of other to avoid tax and or income tax. And it so happened in this case, Beam Singh versus Kaas Singh, the deceased purchased property in the name of another. And he made a statement at that time that I purchased the property in that name of other in order to promote his financial position. So generally Benami transaction means as and when the purchaser can take the property back. There are so many cases they take property in Benami transaction. When the property is sold, the person who purchased the property in Benami will take the money back. That person whose name he will not take. But in this particular case, he said that I purchased the property not to take back, but to be to promote the financial status only. He said that was that statement made by the deceased was accepted. That is with reference to loss of property. Loss of pecuniary interest. In this case, Nagammal versus Shankarappa Naidu. Here in this case, natural sons attached the gift deed of adopted son. So when natural sons are there, still the father adopted son. For that adoption, in that adoption deed, the natural sons signed it. When once you are signing in the adoption deed, you are acknowledging the adoption of that boy as adopted boy. So you are expected to by this point you are losing money. Pecuniary cash, if any is there, that cash will go to that man only. That is this. Another thing is next point is section 26 clause D. Statement as public rights or custom or matter of general interest. So there are so many cases which we find, whether that particular way is public highway, whether that place belongs to public or general, whether it is a, so we find some places there is some vacant site is there. They say that it is meant for park, but subsequently it may be converted into some real estate point. I found like that. So when I found one site and tell somebody, no, commercial project can be taken. It is a public, it is meant for public. But subsequently it was made by the concerned authorities into commercial and commercial complexes are made. So these are the issues. So whether it is there or not, it is from a long traditionally, whether it is a public place or private place is to be said. The person who made that, who has who gets acquainted with that particular place, whether it is public or private, makes statement. That statement is recorded. It will be entertained. But we cannot ask that man who said it as a public place or private place cannot be called back and give evidence. So the relevant case on this point is Basod versus Nawaz Ahmad Khan. Basod versus BUSOID, Basod versus Nawaz Ahmad Khan. In this case, for the person, a statement made by there was a statement in the deed. In that deed, the declarant said that particular place belongs to Masjid. Masjid means mosque. Masjid mosque. There was a dispute relating to a particular place. This place belongs to Masjid. Some document. Somebody written in some document that the person who had written in a particular deed or document stating that particular area belongs to Masjid, then it is Masjid. That is given to Masjid. But no one can that it is my personal land or some other land. So this is also there. Next, existence of blood relation or family affairs. For existence of blood affairs and family affairs, section 5 and 6 are taught collectively. Section 5 section clause E of section 26 or subsection 5 of section 32 speaks about blood relation. Section 26 clause F or section 32 clause 2 of Indian Evidence Act deal with family affairs. While dealing with this, to find out the relationships to document evidence for family relations relate to blood relationship by blood, marriage or adoption, and this relation to family relation, in former case only dead persons and the dispute between dead person and living persons may take place, but in a latter case family relationship, the dispute is with reference to dead person and dead person only. That is to be taken into consideration. And here in case of blood relation, oral and written statements are allowed. In case of section 6, only written statements are accepted. This is main. Otherwise, so far as these things are concerned, section 5 and 6 are explained together. So pedigree, declaration as to relation or pedigree. Pedigree means ancestral relationship. He is so and so, some family tree. He is the son of so and so, father, grandson of so and so, great grandson of so and so. That is what is called the pedigree relationship. We have to think about. There is a relevant case on this point. Kalidindi versus Chintalapati. Kalidindi versus Chintalapati. So in Kalidindi versus Chintalapati, there was a statement that B is the wife of A. B is the wife of the day. That basing on that statement, basing on that gift deed, in gift deed, whether so and so is wife of so and so, whether so and so is the husband of so and so, there may be a question. But in a gift deed said that particular person is the wife of particular person is given. That particular person who is wife is entitled to get the property, inherit the property. This is Kalidindi. Another question is Shivram. In another case, Shivram versus Shivcharan. Shivram versus Shivcharan. So in this case, he said that at the time of executing the will, I was 19 years. So the question of competence will come into question. Whether the person, that is the testator, testator who has written the will was competent to contract or not within the meaning of Section 11 of the Indian Contract Act. But this fellow, this person stated in his will, by the time when I was writing this will, I was 19-year-old. So when the 19-year-old declaration is taken into consideration, because at the time of writing will, he was qualified under Section 11 of the Indian Contract Act. He was competent to write the will. That will is valid, and accordingly, as per the contents of the will, the property is to be distributed. And the seventh point is, in a document relating to any transaction, documents relating to transaction. So whatever information is given in document, it is to be taken into consideration. If any property is to be sold or purchased, the sale deed is the main source of document, and sometimes linked documents are there. Whatever the property must have been purchased some 30 years back, 50 years back, the persons they connected must have been dead, but still whatever is there in the document, sale deed, will be taken in a relevant case, that is in a sale deed, some boundaries are given. So east so and so house, west so and so house, north somebody's house, some A's house. So whether it is A's house or not, some fact in issue question was raised, and this on the sale deed, the boundaries, what are the boundaries were taken for granted, and it was found relevant. And last one, statements of several persons expressing their feelings or impressions. So we say that in any village, who is that particular person, that sarpanch, good man or bad man? The people say that he is a good man, God. Some people may say that bad man, like that. So some opinions are there. So and so department is corruption department, so and so department is corruption free department, so and so is good man, so and so is bad man. So there is a common opinion is there on certain things. There is a common opinion is there on some there. So environment is today is very bad. It is common opinion. Nobody can say no. So and so city is good, so and so city is not good for living. These are the things. These are the common feelings and things. The person who expresses that common opinion cannot say so and so hero is a very good man, great man. What all he earns, he gives to poor people. So there are certain opinions are there. So there may be some hero, he doesn't give even 1 rupee to anybody. He is a bad man, like this. So there are some opinions. These opinions, some people may say woman should not go to some certain fields of job, and that may be the opinion. So these opinions may be entertained by taking into consideration circumstances of the case. Thank you very much, dear friends, for your patient hearing. Thank you very much for taking my channel to 16,700. At the same time, please note that I have uploaded so far 250, nearly 260 lectures on 18 main subjects. They are connected to judicial service and all exams. If you can spare your time, they will help you. Tell your friends, because I am not able to give small lectures, because when I have taken up giant product, if with your inspiration only I will be able to upload more and more lectures. There are some students who are eagerly looking for my lecture. For the last 2 months, I was in some personal problem. I would not able to give lectures. Anyway, I will continue. At the same time, I will have to take up other jobs also. Some of my books are to be revised. When the publisher gives request me to revise, I will have to do. So that is the reason why there may be delay. Anyway, I promise to upload not less than 1 lecture in a week, and I request you to go through the pending lectures which were uploaded long back, so that once you are able to listen all my lectures will help you. If you have unlimited net, you watch my lectures in net only. If your net is very limited, you download it and share it to others, because in case this any remuneration is there, it can be utilized for some charitable purpose. Thank you very much. I never take a single pie. If you do it, you will be indirectly helping some poor or some temples in poor condition, which I wish to dedicate this earning, if any. Thank you very much, dear friend.